We have a special guest today, Paul Velasco of the Velasco Law Group. I'll be introducing him in just a minute here. And a lot of you are familiar with him. I think some of you have actually had him as a guest speaker at some of your seminars. So keep in mind, he's just another friend of ours, an affiliate, and somebody that you should definitely have in your Rolodex when you have a client that needs to do a trust. You know, the other day, guys, I posted on my Instagram, I think it was Saturday, I went to my client's house to go pick up her letters testamentary, notice of proposed action, all the death certificates and documents necessary to close out our transaction. It is a probate. And I was thinking about my other transaction that I have where there wasn't a trust done. So on this property also, there was not a trust, but so they had to retain an attorney, a probate attorney like Paul. But on my other transaction, they didn't even have a trust either, but they didn't have to go to probate. But the problem is everybody involved in the transaction wishes that there was a trust, because now there's a legal battle between the people that inherited that home. And it doesn't have to go to probate because they were added the title, but because there wasn't a trust, there was no, specification as to how the assets would be divided and so on. And so now both people that inherited the home are in a legal battle, and who knows when that transaction will close. So please, I always tell all my clients, the best way to hold title, besides your regular way of holding title, is to consult with somebody like Paul and get a trust for your family. It'll be the best thing that you can do. All right, let me introduce our guest speaker, Paul Velasco. Paul has been practicing law for more than 22 years, and he focuses his practice exclusively on estate planning, probate, and trust administration, and is a well-known probate and trust litigator. And I can attest to that. I've heard about Paul for several years, so he is well known in our industry. He's fully certified as a specialist in the estate planning, trust, and probate law by the State of California Board of Legal Specialization, a distinction held by less than 1% of all attorneys in California. Paul is a member of the Trust and Estate section of the State Bar of California and the Estate Planning and Trust Council of Long Beach. He lectures extensively on trust and estate planning matters for wealth management advisors, corporate trustees, real estate professionals, and other professional groups. Paul and his firm have represented Farmers and Merchants Trust Company of Long Beach, Wells Fargo Bank of North America, Union Bank, and other professional trustees as legal counsel on various trust, probate, and litigation matters. Paul is a graduate of the Loyola Law School in Los Angeles and holds a BA in English Literature from Cal State University in Long Beach. Paul, welcome. We are very grateful to have you as our guest. Please give him a warm welcome, everybody.
Thank you. Thank you, Benny.
The floor is yours.
All right. Thank you, Benny. Well, thank you for that very nice introduction. I appreciate it. And I appreciate the opportunity to speak to your group as well. I don't know how many people have heard me speak, and I try not to repeat myself if people have heard me speak before, but I'm going to go ahead and talk about some of the things that I have talked about in the past. I think a lot of that is important. I'm going to try and get to some new things as well so that people don't hear the same thing over and over again. But as Benny mentioned, I am a certified specialist in estate planning, probate, and trust law. So this is all I do for my entire 23-year career as a lawyer. I worked exclusively in this area of practice. Estate planning. Benny, are you going to allow me to share my screen?
Yes, sir. Absolutely.
Okay, yeah, if you do that, I have a PowerPoint presentation that I can share with everybody. So I've been doing this for a long time. I have a practice of about 22 other people. There's 7 attorneys total, and we practice exclusively in this area, helping people with estate planning as a big part of that, of course, probate and trust administration. So when people pass away, those estates have to be administered, and there are executors and trustees who have certain duties and responsibilities, and we represent those trustees and executors to make sure that they carry out their job. We also deal with situations where there's probate and trust litigation, where things go wrong, unfortunately, within the family and within the estate, as Benny was referring to. Those kinds of disputes happen all too often. And all too often they happen because there was no planning done. The reality is most people don't do anything. Most people die without an estate plan in place. And so when we have to deal with those things, we're in court. We're in court dealing with the disputes, problems. Even when people try and create their own estate plan, sometimes they just don't do it right. So a big part of that, the situations we deal with are situations where people actually did try to do some estate planning, but they just didn't get it right. You know, people nowadays, you can go online, you can go to LegalZoom, you can go to Rocket Lawyer. There are many other online programs that people can use to do their own estate plan. People often go to paralegals and other individuals who will do their estate planning rather than going to attorneys because they think that they're saving money. And the reality is that most people who do that, who go and try and do things themselves, really will have no idea whether or not that was done correctly until it's too late. People, when somebody dies, is when those documents are brought out, when the estate plan is brought out. If they did a will or a trust or power of attorney, is brought out only then. And if it's not done correctly, and many times it's not, unfortunately, it's too late to do anything about it. It can't be fixed. It can't be resolved easily. The only way to fix a document like that when somebody's passed away is to go through the court process, because those documents become irrevocable when somebody passes away. So the idea then is, if you're going to do estate planning, if you're going to do it, you might as well do it right. You know, go through a specialist, use somebody who knows what they're doing. Yes, you may pay a little more up front, but in the long run, it'll save you not just thousands, but tens of thousands of dollars. Let me tell you about a case that I just walked through my door a few days ago. So here's a situation where this woman tried to do her own estate plan. She went through LegalZoom and she did the trust. So she thought that that's all she had to do was her trust. And the way she set it up was this: she has a daughter, but that daughter she hasn't had a relationship with for many, many years. That daughter has 2 children. And this mother, it was, of course, that's her grandchildren. She was the one that really raised them. Unfortunately, her daughter was involved in drugs and just with the wrong crowd. And so for many years, she's just been kind of a drifter, just doesn't have a home, just kind of lives on the streets. And so mom raised these granddaughters who were now 12 and 13 years old. So of course, she wanted to make sure that her grandchildren were taken care of. And so she went to LegalZoom, she did a trust, she named those daughters as those granddaughters as the beneficiaries of the trust, intending to exclude her daughter, and named a trustee and did all of that. Well, unfortunately, she didn't complete it, because in order to complete that, you also have to transfer the title of your property, your accounts, everything into the name of the trust. And she didn't do that step. Now, if she had done it correctly, the correct thing to do would have been not only to do a trust, but also a will. When you do a living trust, you also do a will as a backup document. That backup document is there just in case you leave something out. When you pass away, if there was something that you hadn't put into your trust during your lifetime, the will catches it. And the will says, at my death, I leave everything to my trust. So if she had done both a trust and a will, then she would have been protected, because what happened when she passed away, we learned that the property was not in her trust. It was actually in her individual name. Now, if she had done the will would have gotten the job of putting that property then into the trust at her death. But because she didn't do a will, she died intestate, meaning she didn't have a will. And now what ends up happening when somebody dies intestate without a will, their property goes, according to the law, to her heirs. Well, her heirs at law is her daughter. Her daughter is her heir. So now where she did this trust thinking that she had set everything up for her grandchildren for their future, now, unfortunately, because she did it wrong, this daughter stands to inherit everything. Now, we intend to get in there and try and make some arguments to protect the granddaughters, and we hope that we will be able to work something out for them. But this is the kind of thing that I'm telling you about. These are the kind of mistakes that people make when they don't get the right advice, or maybe they try and do things themselves, right? There's so many different ways that you can trip yourself up. There's so many landmines when you're talking about this area of law. It is so important to get it right and speak with a professional. So that's just one situation. But what I want to talk to you about today is the importance of estate planning. Why is it that we do it? what are the goals, what are the objectives, and then I'm going to talk to you about just some of the basic concepts of estate planning, the difference between wills and trusts, and why we want to avoid probate. And then I'm going to talk to you about the most common mistakes that people make when they do their estate planning, so that you can hopefully avoid those for yourselves and hopefully your clients. So the main goals of estate planning are these, and I'm just going to go through these very quickly. If you don't have an estate plan, you don't get to decide where your property goes. Most people don't understand that the state of California has a will for you if you haven't done one for yourself. And that will that the state of California does is in the probate code, just like this with this woman I just told you about. If you don't do your own will or estate plan correctly, then the state of California says, well, these are the people who will inherit from you when you die. Now, it may or may not be the people that you would have chosen. Certainly, it wasn't the person that this woman would have chosen had she done her plan correctly, but she intended, in fact, to exclude her daughter. And in fact, because of the way she did it, her daughter ended up inheriting from her. So by doing a proper will and trust, or by doing a proper estate plan, you get to decide where your property goes. Not only that, you get to decide how they receive it, right? If you have young children or grandchildren, you don't want them to inherit at the age of 18, right? If something were to happen to you unexpectedly, you would want them to be able to have control of it at appropriate age. So if you do a trust, you get to decide the age at which somebody can inherit from you. You can also, if you do a trust, protect beneficiaries who are receiving government benefits, people who are receiving Medi-Cal or SSI. What a lot of people don't understand is that if you die, if you pass away and property goes to those people who are receiving government benefits, they may lose those benefits because now they have money. And for many of those benefits that they're receiving, they have to qualify. And if now they receive an inheritance, they may be disqualified from those benefits. So if you do an estate plan correctly, you can still provide for those beneficiaries who are receiving government benefits and still allow them to receive those benefits. So you can do both, but you can only accomplish that if you do an estate plan. So getting your money to the people that you want and in the right manner is an important goal of estate planning. The other thing is that you get to choose the people who are managing, who are assuming control of your assets. You know, if something were to happen to you and you don't have an estate plan, usually the very first fight in court is who is it that gets to be your executor? Because when somebody dies, the dynamics within the family change. People are no longer trust one another, right? So somebody passes away, if there's a petition for probate filed by one child, the other child may object and file their own petition. And now it's a fight in court to see who gets to have control. But if you take that away, if you do that by having your own estate plan in place, if you do a will or a trust, you get to decide who those people are. And it's important to decide the right person. Many of the cases that I deal with in trust litigation involve situations where the wrong person was chosen as the trustee or executor. You know, those people who will procrastinate, somebody who's not very honest, who is mismanaging, who is not following through with what they're supposed to do. I get calls from beneficiaries all the time who are telling me, you know, my brother or sister was named as the trustee of my mom's trust, and it's been a year since she's passed away, and we don't know anything. We don't have information. We don't know what he's doing with the money. He's living in the house and not paying rent. What can we do? So that tells me that whoever set up that trust did not choose the right person to step in there. So it's important, by doing your own will or trust, you get to decide who that person would be. And I get to counsel my clients and make sure that they choose the right person. I can tell them what the adverse consequences are when they choose the wrong person. So we also want to maximize the amount that we can ultimately pass to our family when we pass away. If you pass away without having done an estate plan or a will or a trust, if you haven't done it correctly, then thousands of dollars are going to be wasted in court fees, filing fees, publication fees, bond fees, fees that go to attorneys that otherwise wouldn't have to be paid. So all of these fees can be avoided or minimized if you do an estate plan. So these are the goals. We're trying to avoid problems for our family. So what are some of the options? What are some of the things that people do for estate planning? Well, one of the things that people use for estate planning is the joint tenancy titling. Many people use this as a tool to avoid probate. I can't tell you how many situations or problems I've had to deal with because joint tenancy was used instead of doing a will or a trust. Right? So using joint tenancy as a tool for estate planning is something that people do because with joint tenancy, as you all know, there's an option of the right of, there's a right of survivorship. So joint tenancy is simply a manner of holding title to something. If you hold title as joint tenants, the most important feature of a joint tenancy is the right of survivorship. So if you add somebody to the title of your property, for example, and you pass away, well, that person automatically, by right of survivorship, as you know, receives the property. There's no need for a will. It doesn't go through probate, just automatically by the way the title was held. And that can be done also with title to bank accounts and investments and stocks. So people use this as an estate planning tool, but it's a very poor tool. It's a very poor substitute for proper estate planning. Many of the cases that I deal with are situations where people tried to use joint tenancy as an estate planning tool and it went wrong. Let me tell you some examples of that. So I had a client who came to me once who had added her sons to the title of her property. Her husband had passed away. He had passed away unexpectedly, and she was not in good health. So she was talking to friends, and one friend advised her to add her sons to the title of her property just in case she passed away, so that by joint tenancy, they would inherit. They would receive the property and it wouldn't go through probate. So she found a paralegal who was able to do that for her, did a quick claim deed to add her sons to the title. Fine, she thought she was okay. But about a year after that, one of her sons was involved in a serious motorcycle accident and became basically in a vegetative state. He was in a permanent vegetative state. He was no longer capable of managing his own financial affairs. So now with him on title, she was not able to do anything with the property. She couldn't sell it. She couldn't refinance it. So what we ended up having to do at that point is filing a conservatorship petition. We had to get conservatorship for her son. That was a very timely or costly and time-consuming proceeding. It takes about 8 months to set up a conservatorship, and the fees were close to $10,000. And if that conservatorship will also last as long as he is incapacitated. So unfortunately, where she thought when she added her sons to the title of her property that was only going to take effect when she died, no, she doesn't realize, and most people don't understand, that when you add somebody as a joint owner, they own the property today. They are now co-owners with you in that property. And any problems that they may have, whether they become incapacitated or they're going through a divorce, as what happened with one of my clients who had added her daughter to the title of her property. That daughter was now going through a divorce, and that property was now being dragged into the divorce. The husband was making claims against that property. So another situation, a client had added her son to the title of her account, her joint account at her bank. She had done so because she was not well. She felt like at some point in the future, she may need help with her financial affairs, and she wanted to give her son access. She added him to the title, and sometime later, one of his creditors actually found that account. And there was a creditor who had judgment against him. He had gotten into a lawsuit some years back. They obtained a default judgment against him, and now they were trying to collect this money that was in this account, and they were able to take all that money because he was on the title. Now, we were able to get in there, get involved, and get some of that money back for her. But, fortunately, she didn't add him to the title of her property, because if she had done that, again, his judgment would have attached to that property, and there would have been all these problems. So you can see that using joint tenancy is a problem. And people do that, even husbands and wives, when they purchase property today. I believe the most common way that they take title, even to this day, is joint tenancy. Let me tell you a problem that I've had with one of my clients recently who came to me. She was referred to me by her accountant. Her and her husband had purchased a property 50 years ago in Rancho Palos Verdes. They had purchased this property together, and he had passed away about a year prior to the time she came to see me. And she was going to sell her property, and she wanted to know whether or not she was going to have to pay capital gains taxes. So let me tell you, give you some background about that before I tell you this story, before I finish the story. So as you all know, when you purchase property, if I were to purchase property today, for example, for say $500,000, and I sell it 5 years from now for $1 million, well, I'm going to pay a capital gains tax, right? And I'm going to pay a tax on the difference between what I paid for it, which is my basis, and what I sold it for. So that is a gain that I pay taxes on. So basis becomes very important. What is my tax basis in a property that I purchase? Well, in this case, if I bought it for $500,000 and I sold it for $1 million, I'm going to pay a tax on the difference between those two. So what if instead of selling it, though, I leave it to my children at my death? Well, if instead of selling it, I leave it to my children at my death, and that property is now worth $1 million, what is their basis in their hands, my children's hands, when I leave it to them, when they inherit it from me? They get a stepped up basis to the date of death value. That means that when they go to sell the property, their basis is the date of death value, not what I paid for it, but the date of death value. So they could sell the property right after my death and pay zero capital gains. Getting a stepped up basis on property at death is an important thing. Husbands and wives, when one of the husbands or one of the spouses passes away, the property goes to the survivor. If it's titled properly, they get a full stepped up basis to the date of death value. So the survivor could sell property and not pay any capital gains taxes. So let me get back to the story of my client who husband had passed away a year prior. He had bought the property in Rancho Palos Verdes 50 years ago, and now this was worth several $1 million. And she was wondering if she was going to have to pay capital gains taxes. So when we pulled the title of the property, we saw that it was held in joint tenancy, unfortunately. Well, joint tenancy is not community property. The IRS gives a benefit to community property owners. If the property is titled as community property, the survivor gets a full stepped up basis to the date of death value and can sell the property without any capital gains taxes. Unfortunately, that wasn't the case here. This property was held in husband and wife as joint tenants, and now only one half got stepped up. Only his half, the deceased spouse's half, got stepped up to the date of death value, but her half remained the same as it was when she bought it 50 years ago. So now when she sold that property, she had to pay several $100,000 in capital gains taxes, all because of that joint tenancy titling, which could have been avoided if it had been titled as community property or if they'd had a trust. So this is the thing that you can avoid by, and these are the reasons why, to me, joint tenancy is really one of the worst ways that you can take title to property. So these are the problems with joint tenancy. I could tell you so many others that I've had to deal with in my career, but these are just a few. So that's not a good option for estate planning. What's another option that people use, of course, is a will. A will certainly is better than nothing, because a will, at least in a will, you get to express your wishes about where your property goes when you pass away. You pass away, the will says it goes to my family, my children, my spouse. In a will, you get to dictate that. And so it's better than not having anything in place, because without anything, the state of California gets to decide that. But with the will, you get to decide. You also get to pick in the will your executor, who's going to be in control of things if something happens to you. But here's the problem with the will. All wills are subject to probate. So even if you have a will, it's still going to go through the probate process. We're still not avoiding that process. So while it does give you some benefits of being able to name your beneficiaries, you're still going to go through probate with a will. The word probate comes from the Latin verb meaning to prove. You still have to prove in court that the will is valid, that it was properly executed, properly witnessed, and that happens in the probate court. So we want to avoid probate, and here's why. Here are the problems with probate. Number one is that it's an open court proceeding. Anybody can go down to the courthouse, pull your file, see what you owned, who's going to receive that. Their names and addresses of your family members are all in that court file, and a list of what the assets are and the values of everything. And people use that information sometimes to take advantage of beneficiaries. So it's not a good idea to go through court, because everybody gets to see, all those news magazine shows like TMZ and others that have these salacious details about celebrities and their divorce, and there's Britney Spears and her conservatorship and the fighting that goes on in an estate. All of that is gleaned, or much of that is gleaned, from the court files. So nobody wants to air their dirty laundry, so to speak, in court, but that's what happens when you go through probate. So one reason to avoid it is to avoid that public airing of your family issues. The other thing is probate invites litigation. Anytime you're going to court, probate court is the same as any other court. It's a place where disputes are resolved, where issues are fought over. So beneficiaries are fighting with one another. They're fighting against the executor. People can make claims in a probate. Creditors can make a claim against the decedent in a probate. So it's a forum for people to litigate, and that costs money. So another reason to avoid probate is because probate invites litigation. It now takes about a year and a half to go through the probate process, a year to a year and a half. Close, probably on average 15 months at the very least. And that's assuming that things go down smoothly. Often there are situations, there are problems that come up in probate that cause even further delays. So time delays are another reason to avoid probate. It takes a long time to get through that. And your family doesn't get anything until the end of the probate. And sometimes that can be a hardship for them if they have to wait a year and a half. I have probates that have been going on for 5 years because of all the fighting and issues that are going on. So another reason to avoid it. And then, of course, probate is expensive. The fees are expensive because they're based on the size of the estate. In the probate code, it says these are the attorney's fees. It's a sliding scale depending on the size of the estate. The larger the estate, the higher the fees. So I'll give you an example. If your estate consists of, let's just say all you have is property, your home in California, and is valued at $500,000. Well, I know that the attorney's fee on a $500,000 probate is $13,000. But you have to multiply that by 2 because the executor gets the exact same fee. So now you're at $26,000. Plus, there's about $4,000 or $5,000 in costs. So now you're well over $30,000 to probate a house in California. And by the way, if that house had a mortgage on it of say $300,000, and so the net is really only $200,000, they don't calculate the fees based on the net estate. It's based on the gross value of the estate. So the $500,000 number is what they use. And you can see as the estate becomes larger, the fees get higher and higher. This doesn't even take into account litigation fees. If there's litigation that's going on, the attorney gets to charge their hourly rate, and those are referred to as extraordinary compensation. So in addition to their statutory fee, the attorneys and executors can charge additional compensation if there's litigation going on, if there's fighting, if there's creditor claims being filed against the estate, if property is being sold in the estate and the attorney has to provide services, all of that can be charged extra. So these are the reasons why you will want to avoid probate. And how do you avoid probate then? By having a living trust, right? So a living trust is a will substitute. It does the exact same thing that a will does. It allows you to name who your beneficiaries are going to be when you pass away, to designate your beneficiaries. A will has, all trusts, by the way, have 3 positions within them. All trusts. Creator of the trust, often referred to as the settlor, the grantor, the creator. Trustee, and beneficiary. So the trustee, of course, is the person who has all the power and authority to sell the property, to invest the trust money, to distribute the property, to control the trust property. The beneficiary of the trust is the person to whom the assets belong. So if I were to create a living trust at its core is just a contract. It's an agreement. It simply says, let's say I'm going to create the Paul Velasco Trust. I create this trust with all the provisions about where the property goes when I pass away. But it's not enough just to sign the trust and put it away. What you have to also do is you have to fund the trust. So I have to then, once I create it, and by the way, when I create it, I occupy all 3 of these positions. I'm the creator, I'm the trustee because I still want to be in control of my assets, and I'm the beneficiary. These are still my assets. Yes, in the trust it says where my assets will go to my children when I pass away, but that's in the future. During my lifetime, as long as I'm alive, I'm the beneficiary of the trust. So in that situation, I'm not going to really notice a difference, even though I create a trust and put everything in it. I'm still in control. These are still my assets. The way I pay my debts or taxes, nothing really changes. I'm just putting a trust wrapper around it to avoid probate. Ultimately, this trust says, when I pass away, I'm naming a successor trustee. I'm the initial trustee, but in the trust, I name a successor trustee who will step in when I'm gone and have control over everything that I've put into the trust. So when I do a trust, I'm going to transfer the title of my property, my investments, my bank accounts. I'm going to designate the trust as the beneficiary of my life insurance. All of that now goes into the trust, and the trust is now controlling all of that. So when I pass away, my successor trustee will be able to step in and have control over all these assets. With that trust document, they can literally take that trust to the bank and get control of all my bank accounts that are in the trust. They can control my real estate that is named in the trust by recording deeds that give them control over those properties. They can collect money from my life insurance company where the trust was designated as the beneficiary. If I change my business into the name of the trust, they control my business now. Everything is now controlled with this trust document. And now because of that, my successor trustee does not have to go to probate court. My estate does not have to be probated because the trust gives them control over everything. So that's how a trust works. That's how we avoid probate. And these are the main differences between a will and a trust. Number 1, probate avoidance. With a living trust, if it's done properly, I'm never going to go through probate, right? So again, if it's done properly, we're going to talk about how things can be done improperly and you end up in probate anyway. But if it's done right, a trust avoids probate. We don't have to go through that probate process. It avoids a conservatorship also. What if instead of passing away, I became incapacitated and unable to manage my own financial affairs? If I have an accident or an illness and I'm just not capable of managing things, well, my trustee can step in and manage my property during my incapacity and avoid a conservatorship. It avoids Medi-Cal claims. If I have been receiving Medi-Cal benefits during my lifetime, if it's in a trust, Medi-Cal cannot make a Medi-Cal recovery claim against the trust estate. So it's protected. If, however, it's going through probate, in the probate, Medi-Cal can make a claim there. And often that's the largest claim of the estate, because if people were receiving benefits over their lifetime, that's sometimes hundreds of thousands of dollars, and it can sometimes wipe out the entire estate. If you have a trust, it protects against those types of claims. It makes it more difficult. The trust makes it more difficult for creditors to be able to get their assets from the trust. If it's in a probate, it's much easier. They simply file a claim with the court, and the court makes sure that they get paid. That doesn't happen with a living trust. It's much more difficult for creditors when there's a trust. And then remember I said with the probate, you don't have any privacy. Well, you do when you have a living trust, because when you have a living trust and pass away, only the trustee and the beneficiaries get to see the details of the trust, get a copy of the trust, and only the beneficiaries are entitled to see all the assets that are part of the trust. So it's not a matter of public record. So all of that is the difference between having a living trust and going through probate. All right. So those are the main things that I wanted to share with you about just the basics of estate planning, right? And now I want to talk to you about what are the most common mistakes that people make when it comes to estate planning. So before I move on, I just want to see if there's any questions. It doesn't look like you guys have any questions. Certainly you can unmute yourselves and ask, but you can also, in the chat box, if you want to say, list a question, I'll be happy to answer it as we go. So, the old saying, what you don't know can't hurt you. Well, that's not true in estate planning. When it comes to estate planning, what you don't know can and will hurt your family. So it's important to avoid mistakes. And some of the most common estate planning mistakes that people make are some things that I'm going to talk about now. I'm going to talk to you about in the context of dealing with the fallout. So there's a question here that I want to get to. It says, how do you inform your beneficiaries on how to handle the trust? That's a good question. So many people prefer not to say anything to their children about their estate plan, right? They prefer to keep it close to the vest and really not share details. I mean, certainly everybody has their own way of doing things. My recommendation is, look, if you're okay with it, you should share the fact that you have an estate plan with your children and let them know that you have a trust in place and that it's there, it was done to avoid probate. And so your successor trustee will know what needs to get done when you pass away. So it's important to have that discussion with your family, because if you don't tell them, then they're not going to know. Many times people pass away, didn't really tell their families what they had done. And sometimes they can't even find those documents. So it's really important to let your family know that not only that you've done it, but where you keep the documents, the fact that you have an estate plan. Give them the name and address of your attorney so that they can contact the attorney if something happens to you. All right, so here's some of the most common mistakes that people make when they do their estate planning. So number one is, how does your estate end up in probate court even if you have a living trust? Remember I said that one of the main purposes of the trust was to avoid probate? That's why we set it up. We do a trust, we avoid probate if it's done correctly. But a living trust is a contract. The contract has to be set up properly. The contract gives your trustee control over the assets that you put into the trust. Think of your trust as a box that you created and that you put all your assets in the box during your lifetime. If when you pass away, the trustee opens that box and sees that there's nothing in there because you didn't put your property in there, you didn't put your accounts in there, you didn't title things properly in the name of the trust, well, that's a problem. If it's not properly funded, your trust is going to end up going through probate. It's a ticket to probate court. All right. So here's how that happens. So somebody passes away. We often find, even when they had a trust, we find that, hey, there's some assets that were not titled in the name of the trust. Remember the story that I told you earlier about the woman who did her trust through LegalZoom and didn't do it properly, and now she passed away. She didn't put her property into the trust. Remember I said that she was also supposed to have a will? So when you do a trust, you're supposed to have a will. That will is what catches anything that was left out of the trust and then puts it back into the trust at your death. So you do a backup will. But what's the problem with relying on that will? Even in those situations where you do a trust, you have a will, what's the problem with relying on the will to get it into the trust when you pass away? Remember what I said earlier about wills? All wills are subject to probate. So even if you did your plan correctly, you did a trust, but you forgot, you left something out. And how is it that you can leave something out of your trust? It's very easy. Let me tell you, even my clients, when I help them initially to put everything into the trust, as you go through life, you acquire new things. You open up new accounts, you acquire new properties. And many times, even though I counsel my clients, don't put things in your individual name anymore. Put everything in the name of the trust. Even with that counsel, people forget. And so now they acquire a new property, it's in their name and it's not in their trust. Or they've opened up a new bank account and it's in their name, it's not in their trust. Or people refinance their property. In many refinances, often it comes out of the trust. The lender's required to come out of the trust back into their individual names. And then after the refinancing, it never gets put back. So that's how things end up outside the trust. And it's a very common thing. It happens very often. Even like I said, with my clients, people make mistakes. And so when that happens, now we're going to end up in court. Okay, because why? Because now the will catches those things that are in your name, but that will first has to go through probate and then the assets end up in the trust after the probate. Well, how can we avoid that? If it happens so often and people make this mistake so commonly, how can we avoid going to court? Well, there's a case that was decided back in 1993 that we can use called the Estate of Hegstad. That was the case in which a gentleman by the name of Mr. Hegstad did a trust, and he did a trust and most of his assets were actually titled in the name of the trust. He did it properly, but there was one property that was held in his individual name when he passed away. It was a piece of real estate that he forgot to formally title into the name of the trust. So when he died, it was in his name. So what they were going to have to do at that point at his death was do what you normally do. You take his will, you probate the will, you get it into the trust. Instead, the attorney for the estate made a new argument. It was very smart. Instead of filing a petition in the probate court, he filed a petition in the trust court. And he asked the court to recognize Mr. Hegstad's intent to put that property into the trust. How do we know that that was Mr. Hegstad's intent? Because at the back of the trust, Mr. Hegstad put a list of all the assets he intended to put in his trust. And one of those was that property that he had inadvertently left out. So the attorney asked the court to recognize that list as being a part of the fact that that property was on the list of assets as being a part of the trust. Give me an order, judge, that says that this property is part of the trust estate. And guess what? The court agreed. The court granted that petition. And all because the court was able to glean from the trust document that it was Mr. Hegstad's intent, even though he inadvertently left it out, it was really his intent to put it as part of the trust. So the court issued an order saying, yes, it is part of the trust and thereby avoiding probate. Now, this was a case that happened 28 years ago. Now that's set a precedent. It set a precedent that as long as the court knows what your intent was, we can avoid probate. So if your trust has the right provisions, you can take advantage of Hegstad. And what are those provisions? Let me share with you a different screen here. Let me show you what that can be. Let's see. I had it open and now it's not there as I do my share screen. Give me one moment. Just find it for you.
And Paul, while you're looking for that, maybe Dennis, is there anything that you wanted to share with us while you're here? Oh, we got to unmute you there.
Yeah, no, I'm unmuted. Thanks. Hey, I just want to say to Benny and John, and I'll put it in the chat.
Uh-oh. You're muted again. There you go.
Okay. Congratulations to the Cypress office, you guys. #1 office for closed production for the month of March 2021. So congratulations, Benny, John, and all the wonderful agents on the office. You got wonderful people in your office, and congratulations because you had a great closing month. And it's about the agents. So thank you for closings. We still got a lot of year left. I will say this for the first quarter, we are 57 closed transactions up this first quarter over last year. So anyway, the point is, thank you guys. Appreciate all of you. Just want to say thank you. And also, I do have a class Thursday, 1:30 for about an hour and 15 minutes on the loyalty gap and helping agents with their sphere of influence, connecting with them. So we're putting together a great class, and thank you for being in our company. Just want to say congratulations, Cypress office, and all of you.
Thank you. Thank you. Dennis, one more thing that you forgot to mention.
Yeah.
Not only are we #1 for the month of March, guys, we're #1 year-to-date office.
I didn't forget that. I wanted you and John to bring that up, actually. So that was congratulations.
Guys, and you know what? I know that Dennis said, John and Benny, but it's really you guys. It's you guys putting in your best foot forward and taking advantage of this market. Remember when last year when COVID first started, I told you guys you're either going to be 2 months ahead or 2 months behind, and unfortunately, it ended up being more than a year that we are in this situation, and you guys have made the best of it. So congrats to you all.
Congratulations, all the agents, and thanks for the help from the Castlehead and Christy Ryan, the Orange Coast team as well. So thank you guys. And Benny and John, thank you so much. Appreciate your hard work and your leadership.
All right, Paul, back to you, man.
All right, thank you guys. So yeah, unfortunately, I cannot find that now. It's too bad because I set it up initially to be able to, as soon as I could switch over to the other screen and show it to you. But let me just explain to you what it is. So in all of my trusts, we do a statement of intent, right? Intent is very important in the probate law. You have to have a statement of intent that says, look, I intend, one of the main purposes of this trust is to avoid probate. I intend to keep my assets, all my assets in my trust for my entire lifetime. But if I make a mistake, if I inadvertently leave something out of the trust, then I want the court to issue an order like they did in that case, the Estate of Hegstad. I actually cite that in that statement of intent. I cite the case and I say, I want the same result if I leave something out. The other thing that I do is in each trust that I do a schedule of assets. I list all of the assets that my clients own as of the date they're doing the trust, their bank accounts, their investments, their properties, their real estate, everything they own. In addition to that, I do a catch-all that says not only these things that I've listed above that I own today, but anything else I may acquire in the future, such as real estate, investments, timeshares, copyrights, properties. So a non-exhaustive list of things I may acquire in the future as well. So in the 23 years I've been doing this, I've never once had to probate one of my trusts. Why? Because even though clients have made mistakes, we've been able to file these petitions with the court. Because of the provisions that we include in the trust, the court can see, oh yes, it was the intent to include that in the trust. So all of these things are important. I will tell you, most trusts do not have these provisions. Even though this case has been around for so long, most trusts do not take advantage of the holding in this case to have a statement of intent, to make it clear that your intent is to avoid probate, to have a schedule of assets and a list that a court can rely on later to put things into the trust and avoid probate. So it's important to have this. It's a big mistake. It's a very common thing. And unfortunately, many times every year, we have to help clients whose trusts were drafted by other attorneys or other places, and they did not have these provisions in the trust. So important to do that, to avoid that. I see I have some questions here, so I'm going to go get to those. And by the way, congratulations to you guys for your success. It's great to see that you guys are so successful at what you do. All right, so when there is a trust in place, property is sold, new home is purchased, property is added to the trust. That will also be included in the will that is attached to the trust. It's not included in the will. The will is just a catch-all. All the will says is, when I pass away, if there's anything in my name, I leave it all to the trust at my death. So it doesn't, you don't have to add anything to the will. What you do want to do is add the title of the trust to the title of the property to the trust. So yes, when you buy a new home, take title in the name of the trust. Don't put it in your individual name. Should a husband and wife have separate living trust? It depends. Many situations, if everything is community property, and if it's a marriage of the long-term marriage, children of the same marriage, then typically you're going to have a joint trust, one single trust. But if you have separate property, if you came into the marriage, you have separate property, you may want to have a separate living trust. But you also, if you have children from different marriages, if you've maintained your assets separately, a separate trust may be more appropriate. So it really depends on your situation, okay? How often do you need to revise your trust? Well, My recommendation is to review it at least every 3 years, just to make sure that your family and financial circumstances haven't changed in such a way that your trust needs to be updated, right? Often your relationships change with the people that you have chosen as trustees and executors, or even as beneficiaries. It may not 3 years later reflect the same interest that you had when you set up the trust. So it's important to review that at least every few years, okay? And can you do it on your own, or do you need an attorney? Look, my recommendation always is to do it with an attorney, to do these changes with an attorney. It doesn't cost as much to do when you initially set up your trust. There's a flat fee that typically is paid to do the estate plan. But once the estate plan is set up and all you're doing is changes or amendments, it doesn't take the attorneys more than a couple of hours to do changes. And so best to let the attorney handle those. There's been many, many situations where clients have tried to do these changes on their own, and they've ended up making mistakes and now, creating problems. So best to have a professional do that. All right, so that's one mistake that I wanted to talk to you about. Here's the second mistake, and I'm going to talk to you about it in the context of, well, the importance of doing it. Let me just give you a case study. Mike and Carol, remember the Brady Bunch? So Mike and Carol come to me. We've kind of updated them from the 70s, but here's Mike and Carol. Here are their assets. They've got their home, some rental properties. They've got mutual funds. They've got a total estate of about $2.2 million, right? The size of the estate doesn't matter, but they come to me and they want to do an estate plan. And it's so important for husbands and wives to understand that an estate plan for a husband and wife, there are different options. There are different ways that things can be set up. It's not a one size fits all. But I will tell you, most of the clients who come into me, who bring their trust into me to review, they have no idea what their trust says, right? So it's important to get it right. And here's what you have to think about. What type of trust should you have if you're married? There's not just one, there's several. So it answers this question: what happens with the trust when the first spouse dies? A trust, when you're married, a trust controls your assets in 3 different phases of your life during the joint lifetimes of the spouses, right? And in that phase, it's very simple. The trust simply says, hey, these are our assets. We're the creators of the trust. We're the owners of the assets. We can use these trust assets however we want. We can change the trust at any time. It's revocable. So during your joint lifetimes, you're not going to really notice a difference in the way that you deal with or own your property. You can do with it whatever you want. The third phase of your life is what happens with the trust assets when you both pass away. Well, that's easy. You're going to talk about leaving it to your children, your family, your grandchildren. We'll talk about that, but everybody thinks about that, right? Where does everything go when we both pass away? But what most people don't think about is that second phase for a married couple, and that is what happens with the trust when the first spouse dies. Can the surviving spouse change the trust? Can the surviving spouse revoke it or change all the things that they had set up initially when they were both alive? Can the survivor just use and spend all the money without restrictions? Or what if the surviving spouse remarries? Can the survivor leave it all to a new spouse? Are the children protected? All of that depends on the type of trust that you chose, right? So here are the options. Here are the different ways that a trust can be set up if you're married. Number one is what often is referred to as an A/B trust option. So what happens is this: when Mike and Carol initially did their trust, it's a single family trust noted by the box at the top, Mike and Carol Brady Living Trust. Everything is in that box. Their assets, their home, their investments, everything is titled there, and they have complete control of it during their lifetimes. But with this option, if there's an A/B trust option, what happens is the first death happens and the survivor is now required to split the estate up into 2 halves, 2 trusts, into what's known as the survivor's trust and the decedent's trust. And typically what it represents is the deceased spouses and the surviving spouses 50-50 interest in the estate. If everything is community property, the estate gets divided so that 50% ends up in the survivor's trust and 50% ends up in the decedent's trust. We literally take all the assets from the Brady family trust, we get date of death values of everything, and then we split it up so that the survivor's trust has 50% and the decedent's trust has 50%. The survivor typically is still in control of both trusts, still the trustee of both trusts, and has control over the assets on both sides. But these 2 trusts have very different characteristics. The survivor's trust represents the surviving spouse's portion of the estate, and the survivor can do whatever they want with that half. The survivor can spend it the way they choose. They can give it away if they wanted to. They can retitle the beneficiaries. They can change the beneficiaries, even though Mike and Carol may have left it all to their children. When they initially set up the trust, the survivor can change where their portion would go. The survivor can cancel this trust entirely and leave all the assets to somebody else. The survivor could remarry and leave it all to a new spouse. No restrictions on what the survivor can do with the survivor's trust. But the decedent's trust becomes irrevocable. The survivor can no longer change that half. That half is now set in stone and says when the survivor dies, whatever's left in that trust goes to the children, the way the deceased spouse had set it up. So the survivor cannot change the deceased spouse's wishes. But that money sits there for the survivor's lifetime, just in case the survivor needs that part. If the survivor does not have enough money or income coming in to maintain their accustomed standard of living, then the survivor can use the money in Trust B for their health, support, or maintenance to maintain their accustomed standard of living. So it's there if they need it. If they don't, then the survivor leaves that there and that money ends up going to the children when the survivor dies. That is an AB trust. That's how it works. Now, you can see that there's some level of complexity here. There's some work that has to happen. There's some administrative inconveniences, if you will, with this type of trust. Why? Because when the first spouse dies, the survivor is going to have to come back to the attorney and say, okay, what do I do now? And then the attorney will help them divide the trust into two trusts. We'll create these two sub-trusts and we retitle all the assets into the two trusts. And now the survivor manages those two trusts during the survivor's lifetime. That decedent's trust also has to file a separate tax return every year. In addition to the survivor's individual return, the decedent's trust files a separate tax return every year. So you can see that there's some moving parts here to this type of trust, but this is one option that people can choose. Now, let me give you a summary. So just to summarize what we talked about, with an AB option, the assets at the first death get retitled between A and B. The survivor is still in control of both trusts as the successor trustee, but that B trust becomes irrevocable. The survivor cannot change who the beneficiaries are when the survivor dies. That they'll go down to the children the way the deceased spouse initially set it up. The survivor can change their portion. They can use and spend their portion, the A trust, however they want. They can change the beneficiaries. They can revoke that completely. But there are some administrative burdens that go along with this kind of a trust. There's work that needs to get done that the attorney will have to help the surviving spouse to do. And that B trust has to file a separate tax return every year. That is an AB trust, okay? Let me just tell you, most people, most married couples who've done a trust, many of them, I would say probably most, have this type of a trust and don't even know it. So it's important to know what you have. How is your trust set up? All right, here's the second option. The second option is what I refer to as a simple trust. Because why? Because it's very simple. First spouse dies, everything just stays in the survivor's trust. There's no division. Nothing gets split up. Everything just stays in trust for the survivor, and the survivor has complete control. So the entire estate now is just held for the survivor. The survivor is the trustee, so still has control over everything. But this trust remains 100% revocable. So the survivor can change not just their half, they can change the entire trust. If the survivor remarried and wanted to leave it all to a new spouse, they could do that with this option. If the survivor wanted to change the beneficiaries and instead of leaving it to the children, leave it all to the grandchildren, they could do that with this option. If the survivor wanted to cancel this trust, revoke it, take all the assets out and form a new trust, they could do that. There are no restrictions on how the survivor can use the money, spend the money, or change the trust. This is the other side, right? This is a simple trust option. So those are the two options that you have so far. Now, these are the only two options really that you're going to get from any other attorney, because really these are the only two options that are out there for a married couple, unfortunately. But about 8 years ago, we created a third option. Why? Because our clients did not like the fact that these to many clients of mine, when I explained these two options, they seemed like two extremes, right? This A-B trust was too complicated. They didn't really want to have the survivor have to go through all of that. But this simple trust gave the survivor too much power to just spend it all or give it all away. And they could leave, remarry and give it all to a new spouse. They didn't like that either. And they want to know, wasn't there something in between? So we created something in between. We created what we refer to as a hybrid trust, right? A hybrid trust. So this is I call it a hybrid trust because it's a combination of these two trusts that I just talked to you about earlier. So with a hybrid trust, here's what happens. The first spouse dies, everything goes in trust for the survivor. The survivor has complete control as the trustee, as they do with all these options. The survivor's in control, and the survivor gets to use and spend the money for whatever the survivor's needs. So if the survivor wants to, live their lifestyle, they can use and spend the money, not a problem. But this trust becomes irrevocable at the first death in the sense that the survivor can no longer cancel the trust. Remember I said with the second option, the survivor could just cancel it all and start a whole new trust and leave it all to a new spouse. You cannot do that with this option. Instead, everything stays in a simple trust, so we don't have to worry about dividing the trust into two and all the work that goes with that. No, the first death, it's very simple. There's very little for the survivor to have to do with this option, but leave everything in the trust. But this trust says, survivor, you cannot cancel it, and you cannot take assets out to leave it somewhere else. That would defeat the purpose. What you can do, though, is if you want to sell a property, no problem. You can sell the property, but once you sell it, the money's got to come back into the trust. You can sell it and buy another property. That new property has to come back into the trust. You can change assets in and out of the trust, no problem. You can change investments, but you got to keep the assets titled in the name of the trust as long as you're alive. As long as you use them and consume them for yourself, you can do that, not a problem. And then what happens with everything then when the survivor dies? Well, each of them gets to decide what to do with their 50%. So the survivor, when they create the trust initially, Mike and Carol Brady, you say, look, I want my half to go to my children. So the other spouse says the same thing. So initially that trust says that when they both pass away, everything's going to the children. But the survivor can still change their portion. Their 50%, if they want to change the beneficiaries, even after the first spouse dies, they can change it as to their half. But they cannot change the deceased spouse's beneficiaries. That half has to go according to the way the deceased spouse set it up initially when they did it. So these two things then, this is the way it's set up. So essentially this trust says this, honey, if I die first, I'm leaving everything to you in the trust. You get to use and spend it however you see fit, but you cannot cancel the trust anymore, and you cannot take assets out of the trust and leave them somewhere else. When you pass away, at least half of whatever's left has to go to the kids the way we set it up originally. The other half, you can do with it whatever you want. That is the hybrid trust. So you can see then that there's now another option, a way to leave things that protects your family so that the survivor can't just do whatever they want with it and give it all away to a new spouse at the first death, but does it in a way that we don't have to have that complexity of the AB option that we talked about in the beginning. So these are the different ways that you can set up the trust. So you can see that these are very different circumstances, very different consequences for each of these options. So each family gets to decide which option works best for them, all right? So these are the things that people skip, that people miss, that people don't really get right. Whenever I see a trust when somebody brings a trust to me that was done somewhere else, and I go through it with them, most of the time it does not reflect what they would have wanted, what they would have chosen had they been given an option. So here we give them an option, and now they can make those changes. So that's what I have for you today, guys. I know there's other things that I can share with you, but I just wanted to give you that kind of basic background about trust and how they work and the different ways that things can be set up. Are there any questions about that?
Does anybody have any questions? I want to say, Paul, I love your energy. We're definitely going to pass out your information, and guys, use this man as a resource and refer business to him because, your clients are really going to thank you one day when they have a problem and it goes away because Paul took care of a trust for them, and now it's just, easy peasy. So please keep him in mind, guys. After your clients have moved into a property, let them know, hey, the best way to hold trust. I don't know if you know this, Paul. Many years ago, I don't know if it was Frank Sinatra or who, but they asked a guy in the Rat Pack. They said, hey, what do you think is the best way to hold title? They go, well, I hold title the way Bing Crosby holds title, and that's in a living trust. So in case you didn't know that one, that's an old school one for you. But anybody have any questions? Anything for Paul, guys? I will assume you all took copious notes and you are now knowledgeable in the field of probate. All right, Paul. Well, thank you very much again for being our guest. We really appreciate you. Thank you, and we look forward to doing some business with you, my man.
All right, well, thank you. Yeah, feel free, as Benny said, to just use me as a resource. If you have questions or issues come up, feel free to pick my brain. I'm happy to help you out.
Thank you again, Paul. Thank
All
you
right,
again.
thank you. Thank you all.
All right, everybody. Congratulations again. Kicking butt. I love it. We're really proud of you guys. You guys are amazing. And you know what? Today I'm taking the guys out for a little treat. And maybe in about a week or two, ladies, we will have to do like a tea time or a late afternoon lunch. So anyways, everybody, congratulations. Thanks again. Make it an amazing week.